Hello, friends. Today we'll discuss a very important topic which has been in current affairs since last 1 year. That is the topic of governor. So, if we see newspaper of the last 1 year, the issue of governor in various states have been upcoming in various Supreme Court judgments. So, how it is important for UPSC is, from prelims perspective, we need to know what are the important constitutional provisions regarding the governor, and also there are various committees which have been appointed from time to time, which have given certain recommendations to improve the effectiveness of governor's office. So, we'll discuss those committee recommendations, and from the perspective of mains examination. The very important point here is role of governor in Indian polity. So, what are its powers? What are its function? Along with that, there are some discretionary powers given to the office of governor. We'll discuss those, and there are various Supreme Court judgments which have come from time to time, which have changed the office of governor. So, we'll discuss those topics from mains perspective. So, before dwelling into the topic, let's understand why the topic of governor has been in news. So, there are mainly three main contentions regarding the governor's office. First is there has been a delay in giving assent to the bill passed by the state legislature by respective state governors. This has been mainly observed in states of Tamil Nadu, Kerala, Telangana, and Punjab. And secondly, there has also been an issue regarding appointment of vice chancellor to state universities. We'll discuss in which all states it has been highlighted. And lastly, constitution gives certain discretionary powers to governor. Now that discretionary power has been in controversy in news lately. So we'll discuss what are the controversies around it. So before dwelling into the topic, let's understand the basics behind it. So as you all know that India is a federal polity. Now what does federalism mean? Federalism is nothing but the power of governance is divided between various constituents. So in case of India, it is between union government and state government. So if the executive power in union and state is such that at center, as you all know, we have union government. For that union government, the legal head is President of India. Now, all the executive power, all the decisions are officially taken in the name of President. But the President is termed as DG or head. Okay. So, what does this term mean? That he is only a nominal head of the state. Actual powers are vested in Council of Ministers headed by Prime Minister. As our constitution says that President shall act upon advice of Council of Ministers. So there is no independent power given to the office of President. He has always has to act on the advice of Prime Minister. That's why he is known as DG or head. Similarly, parallelly at state level also same concept is envisaged by the constitution. So at state level, we have legal head as governor, like parallel to president at central level, and he acts upon advice of Council of Minister headed by Chief Minister. So from this we understand that similar type of government structure is envisaged by constitution at both central level and state level. At center we have president, the parallel office at state level is that of governor. At center we have Council of Ministers headed by Prime Minister. Parallelly at state we have Council of Ministers headed by Chief Minister. So, now there are certain differences between President's role and state governor's role. We'll discuss that in further slides. So moving on, let's first discuss what are the basic constitutional provisions regarding the governor. So this is the main area where prelims question come. So we need to discuss this in utmost detail. So first is regarding the appointment of governor. So Article 155 talks about how the government will be appointed. Governor will be appointed. Now, we all know that president is elected by a special electoral college. But similar kind of setup is not there for state governor. Article 155 just says that the state governor will be appointed by president by a warrant under his hand and seal. So it simply means that president will appoint the governor. There is no concept of election here at state level. Now, if we compare this to USA, in USA, the governors of the federal units are directly elected. So we have not borrowed this concept from USA Constitution, but we have borrowed this from Canada. In Canada, the provincial governor are always appointed, like India. So this concept of appointing the governor has been borrowed by Canadian Constitution. Now, one may say that since president is appointing the governor's office is an employment under president or an employment under the central government. But Supreme Court in its judgment has clearly mentioned that governor is not an employment under central government, but an independent constitutional office. Now, what does the independent constitutional office signify? That the governor, though he is appointed by president, shall not act upon shall not be a subordinate to the president's office or not be a subordinate to central government. He shall act independently based on his role given in the constitution, and his tenure is also safeguarded. Now, the constitution has also specified qualifications. Those are only two: that governor should be citizen of India and he should have completed 35 years of age. Those are the only two qualifications specified by the Constitution of India for appointment of governor. And secondly, there are certain conditions of office. These are the conditions of office which are specified in Constitution for the governor. First thing is, a governor shall not be a member of parliament or state legislature. So he shall, if he is a member of parliament or state legislature and he is appointed, it is deemed that he has vacated his office. And secondly, he shall not hold any office of profit. So term office of profit means that he shall not be interested in any government contracts, and there are various other provisions to the office of profit. So the person who is supposed to be appointed by the governor shall not hold any office of profit. Now secondly, the salaries, emoluments and allowances of governor are determined by parliament and not by state government. This should be clear. And it is also mentioned in Constitution that those salaries and allowances shall not be diminished during the term of office. Now this is important to ensure that governor acts independently. So once a governor is appointed, his salaries and allowances can't be reduced. Now, the Constitution gives the term of governor is given as 5 years, but it is subject to pleasure of president. Now, this is termed as doctrine of pleasure in concept of appointment of governor. Now, what does the pleasure of president means? That a governor can be removed from his office anytime by the president. Now, this has been the topic where most of the controversies arise. So, if you go back in the history, in 1970s, when the first time the Indian National Congress was defeated. So what happened was all the state governors which are earlier appointed by the Congress government were removed and other governors were appointed. So in this regard, we have a very important Supreme Court judgment called Bommai versus Union of India. We'll just discuss it in the further slides. Now, one more important topic to remember regarding removal is there are no grounds mentioned in the Constitution for removal of the president. So a president can remove the governor, but there are no grounds specified. For example, if we see in case of Supreme Court judges or in case of president, the Constitution clearly specifies certain grounds on which a president can be impeached or a Supreme Court judge can be removed. But similarly, for the case of governor, there are no grounds specified. It only mentions that the term is 5 years subject to pleasure of president. Now, similar to president, governor also enjoys certain immunity. Now, for his official acts, he enjoys personal immunity from legal liability. This means that whatever the conduct of governor is or the decisions of governor are, that cannot be scrutinized by judiciary. This is important to ensure that there is a separation of powers between the various constituents of government. Now, and for the personal acts. Now, personal acts, there are two cases, one regarding to criminal proceedings and one regarding to civil proceedings. So, when the governor is in the office, no kind of criminal proceedings can be initiated against the governor. He cannot be arrested or cannot be imprisoned. Now, with regards to civil proceedings, case can be instituted against governor's office, but only after giving 2 months notice. This is only for personal acts. For official acts, he enjoys personal immunity from any legal liability. So this immunity is necessary to ensure that the office of governor is independent and there is no political intervention in the office of governor. So these are the important constitutional provisions regarding the office of governor. Moving on, let's see what is the constitution envisages the role for governor in Indian polity. Now, basically, as we have seen that governor acts as the head of the state at an executive level, but the Supreme Court in various judgments have mentioned that the government has dual role. He acts as a head of state and also representative of center. Now, as a representative of center, it is governor's duty to ensure that the governance in the state is carried as per the constitutional provisions. So, there is a special Article 356 in which it says that constitutional emergency can be imposed in the state, and to impose that, a governor can recommend it through a report. So, it is one of the role of duty of governor to recommend imposition of constitutional emergency. Apart from that, the constitution also gives two duties to center with regards to governance in state. One is in Article 355. It states that center need to protect the state from external aggression and internal disturbances. So it is the center's duty to ensure that the state is protected from any external aggression and also any internal disturbance. And it is also to ensure that governance is carried on in accordance with provisions of constitution. So the governance in the state complies with constitutional provisions and does not violate the constitutional provisions. So these are the important duties of the center with regard to administration of state. Now, how does center discharge the duties? Is through governor. That's why it is said that governor is representative of center and acts as a link or channel between center and state. Now, this we have seen that as constitutional head of state, governor is responsible for appointment of chief minister and ministers, and all executive actions are formally taken in his name. So this is the role of governor, which is envisaged in the constitution. Now, moving on, this is the area where many judicial cases have been ongoing recently. That means governors assent to the bill. So, let us understand how a state act is passed. So, once the state legislature passes any bill, it has to go to governor. And once the governor office gives an assent to that bill, then only it becomes an act and it is implemented. So, governor's assent is an important step for a bill to become an act. Now, once the bill is passed by state legislature, what options does the governor have is covered under Article 200 of the Constitution. Now, Article 200 states that the governor has four options. One, he can give an assent to the bill. Once the assent is given, now the bill will become an act. Second, he can withhold the assent to the bill, which means that he will not give an assent and that the bill will not become an act. Now, thirdly, it says that the governor can return the bill for reconsideration. If for reconsideration of state legislature, so governor along will give the bill back to the state legislature for reconsideration. But the catch here is that if bill is passed again by legislature, then governor has to give assent. He can't again withhold or return the bill for reconsideration. So once the bill is given for reconsideration, the governor has and the state legislature passes the bill again, then governor has to give the assent to that bill. But this third point is not applicable for money bill. Now, why so? Because there is a provision that money bill, whenever it is introduced in state legislature, it is always to be introduced on the recommendation of governor. So, since the prior recommendation is taken of governor, it does not make sense to again return the same bill for reconsideration of state legislature. So, that is an exception. Now, fourth point is the governor can reserve the bill for consideration of president. This means that the governor will not take any action on it. It will reserve the bill for president's consent, and then the president's consent will be required for that bill to become an act. Now, if the such bill is reserved for consideration of president, again president will have three options. He will grant an assent, he will withhold assent, or he can direct the governor to return the bill to state legislature for reconsideration. So these are the three options for the president. Now, if we see in this regard, when can a governor reserve a bill for consideration of president? Now, this has not been mentioned in the constitution, but there is one place where it is mandatory for the governor to reserve the bill for consideration of president. That is, when any bill endangers the position of state high court. For example, if any bill tries to reduce the powers of state high court, then it is mandatory on the part of governor to reserve that bill for the consent of president. Otherwise, there are certain examples where a governor can, reserve the bill for consideration of president. One such is if the bill is against the provision of constitution, if it is against directive principles of state policy, or it deals with any compulsory acquisition of property under Article 31A. So in this case also, governor may reserve the bill for consideration of president, but in case of state high court issue, it is mandatory for governor to reserve the bill for president assent. So these are the provisions regarding governor's assent to bill, which is covered in Article 200. Now, this is the one topic, and second topic which we have seen, which is in news, is regarding governor's discretionary powers. Now, let's see Article 163. Okay, Article 163 specifies that Council of Ministers, headed by Chief Minister, is to aid and advise governor in exercise of his function, except. Now, this exception is very important. It says that except in so far he is required to exercise his function in his discretion. So, if we compare it with the center, in center, it is said that the president will always act upon the aid and advice of Council of Ministers. Also, there was a 42nd amendment to the constitution where such advice was made binding on the president. So, in center's case, it is very clear that president has to act always upon aid and advice of Council of Ministers. But in case of state, the constitution itself gives certain discretionary powers to governor. This exception is the source where the discretionary powers of governors arise. So, therefore, unlike president, who has to act upon advice of ministers, some constitutional discretion is granted. Now, let's see what are those constitutional discretion. So first is reserving the bill for president assent. As we have seen in previous slide, that one of the options with the governor is that he can reserve the bill for consideration of president. Now that is the discretionary power of governor. In that case, he is not required to act upon advice of council of ministers. Now second case will be report recommending president's rule. So we have seen in previous slide, one of the role of governor is to act as a link between center and state, and in that role he can submit a report to governor recommending president's rule when the governance in the state is not been carried out as per constitutional provision. So that report he acts at his own discretion and not as per the advice of council of ministers. Similarly, when a governor is also the administrator of adjoining union territory, then he acts independently. Now, for example, case of Punjab, Punjab's governor also acts as the governor of Union Territory of Chandigarh. Similarly, Telangana's governor also acts as the governor of Puducherry. So, when they are acting as the governor of Puducherry or Chandigarh, they have to act independently and not on the advice of Council of Ministers. Now, there are other certain provisions also, like for example, one covers the 6th schedule area. There is certain amount payable to the tribal district council as per 6th schedule. In that case, he has to exercise his own discretion, and there are also certain responsibilities under Article 371 to 371J. This is mainly for the development of backward areas, like for example, Vidarbha or hill areas in Manipur. So for their development, there are certain responsibilities in the constitution. In that case, the governor acts independently. So this 5 points are given are constitutional discretion. That means it is mentioned in the constitution that on these cases, governor has to exercise his discretion. Now, there are also some situational discretion. These are not mentioned in the constitution, but as per parliamentary convention or as per this situation may arise and where governor will require to exercise his discretion. Now, first is appointment of chief minister when there is no clear majority. So, for example, after the elections are held in a state legislature and no party has a clear majority. Now, in that case, a governor can exercise his discretion. He may call upon the largest party to form a government and may give certain time to prove his confidence on the floor of the assembly. So, that is where he can exercise his discretion. Or when a CM dies suddenly and there is no obvious successor. In that case also, governor will exercise his discretion. But after exercising discretion, the government which is formed, they have to prove their majority on the floor of the assembly. Unless that, they cannot form a government. So, then again, second situational discretion is dissolution of assembly if council of ministers have lost majority. So if the council of ministers have lost majority or they have lost confidence, then the governor may direct to dissolve the assembly. Now, this is also discretionary power, but this is based that the basis of this is that the government or the council of ministers lose the confidence of assembly. That is, they lose the majority in the state assembly. Then, in these cases, governor can exercise his discretion. And last issue regarding the governor is his role in state universities. Now, basically, state universities are established through laws passed by state legislature. So, all the functioning of the state universities, appointment at the state universities are mentioned in that law. Now, in most of the laws, in most of the states, the governor acts as ex officio chancellor in state universities, and he acts independently in this role from council of ministers. Now, this provision was introduced mainly to ensure that the universities in state are free from political intervention, that state government doesn't have any role to play in the administration of state universities. To ensure that there is no political intervention, in most of the laws, most of the states, governor only acts as the ex officio chancellor. And as the role of chancellor, his main duty is to appoint the vice chancellor. And how actually the vice chancellor is appointed is, there is a search cum selection committee which recommends certain panel of names to the chancellor. And from that panel, the chancellor, that is nothing but governor, will select one name who will become the vice chancellor. Now, this process has also been in a lot of controversy in various states. Now, this process of appointing the vice chancellor is also as per UGC regulations. Now, most of the higher educational institutions receive some kind of grant or aid from UGC. So, one of the conditions of receiving the grant or aid is to follow its regulation. That is the case. The most of the state universities follow this process of appointing a vice chancellor. Now, let's see. Now, we have discussed all the provisions regarding the governor. We have discussed the constitutional provisions. We have discussed his role in states' legislative powers, and we have also discussed his role in state universities. Now, around it, only there are a lot of current affairs. So, we'll see what are the current issues of the governor. Firstly, let's take the state of Tamil Nadu. The first issue is the governor refused to read the parts of assembly address and introduced his own words. So, as you all know, it is customary for the governor to give a speech at commencement of the first session of the year. Now, generally, what happens is that the text of the speech is given by the ministers, and he just had to read it and adopt the same text. That is the parliamentary convention. But what happened in case of Tamil Nadu? The governor refused to read certain parts, and he has inserted his own words, and this was objected by the state assembly. Secondly, there is dispute over need bill. So, governor has refused to give his assent or has withheld the assent on this bill at his own discretion. Now, thirdly, there is certain a bill to transfer the power of appointing the vice chancellor from the governor to the state government. As we have discussed, the governor also acts as the chancellor of state universities, and as in chancellor, his main duty is to appoint vice chancellor. So that is the role of governor, and in that role he acts as his own discretion. But Tamil Nadu government has introduced one bill which will transfer that power from government to state government itself. Now, this bill has also no assent has been given by governor to this bill, and that's why this bill has been an issue. Now, lastly, there has been case where the governor of Tamil Nadu has delayed giving assent to a lot of the bills. So, state has passed a resolution in assembly, and it has urged the president to fix timelines for assent to be given to the bills. So, right now in Constitution, if you see the Article 200 does not mention any timeline in which the governor has to act. Okay, so legally the governor can keep any bill pending, but it is against the parliamentary convention. So Supreme Court in its judgment has said that to keep bills pending as long as possible is not as per the provisions of Constitution, and it violates the Constitution. So the Supreme Court has not given any timeline as of now, but it has said that the governor should act as soon as possible. Now, this is the issue. Similar issue has been faced in case of Telangana. Telangana also, there has been delay in action by governor or several important bills. So these are the two states where this issue has been faced, and both the states have gone to Supreme Court with writ petition highlighting the inaction by the governor on the state bills. Now, coming to West Bengal, case of West Bengal, there have been disagreements over administration and university appointments. So here also there have been issues regarding certain role of governor as vice chancellor, as the chancellor of universities. And similar in Kerala also you have seen same role. The governor has sought resignation of 9 vice chancellors. And governor publicly announced that he would not give assent to certain bills. Now, these are the various issues which have been in the news regarding the governor. We have seen what are the background provisions to this news. Now, let's see, with respect to these issues, what are the recent Supreme Court judgments in this case. In case of the case involving the Punjab government, the Supreme Court clearly mentioned that governor is only a titular head of state and cannot obstruct bills passed by legislature. It means that governor has to act upon the advice of the Council of Ministers and headed by Chief Minister while giving an assent to the bill, and he cannot obstruct the bills passed by state legislature. Similarly, in case of Telangana, the Supreme Court has mentioned that governor should act as soon as possible and not sit over the bills. Because if he sits over the bill, it may cause gubernatorial procrastination. This is the term used by Supreme Court. Gubernatorial term simply means relating to governor's office, and procrastination is nothing but delay. So this is the term simply means that delay in governor's activities. So the act of delaying the assent is causing this, which has been highlighted by Supreme Court. So Supreme Court has mentioned that bill should be written as soon as possible. And in case of Tamil Nadu, the case is still ongoing. And the main important issue in this case is interpretation of Article 200. So Article 200 deals with giving assent to the bills. Now, the main ongoing case involves interpretation of Article 200. And main interpretation is to what extent the governor can exercise his discretion in exercising his powers under Article 200. So that judgment, the next hearing is postponed to December. So soon we may also have a clarity, or we may have a Supreme Court judgment regarding Article 200. And also in this ongoing case, Supreme Court has acknowledged the need to address whether there has been delay in governor's constitutional function. So in all these cases, one term which has been highlighted in many news channels is constitutional punctuality. So what does this constitutional punctuality means? Any office or any role mentioned in the Constitution, they have to carry their acts in a reasonable time period. Just because the provision doesn't mention any fixed timeline, the that cannot be used to delay acting or delay in carrying out their own function. So that is the meaning of constitutional punctuality. So in case of governor, it clearly signifies that the governor cannot indefinitely sit on bills or cannot indefinitely not act upon any of the bills or any of the actions just because the constitution doesn't give any timelines for it. So this is one important term, constitutional punctuality. Now, these are the recent Supreme Court judgments. Now, from mains perspective, there are also various past Supreme Court judgments which you can use in your mains answers. First is Rai Sahab Jawaya Kapoor versus State of Punjab. In that, the Supreme Court mentioned that governor is formal head with real executive powers vested in Council of Ministers. So, in this, the Supreme Court made it stand clear that governor is only a formal head. Similarly, in Shamsher Singh case, it mentioned that governor's satisfaction is based on satisfaction of Council of Ministers. So it also again clearly mentioned that governor cannot act upon his independently, and it has to always act upon advice of Council of Ministers. And regarding the appointment and dissolution of assembly, there is an important case called SR Bommai versus Union of India, in which it has said that majority testing should be based on floor of the house and not governor's subjective assessment. Now, in previous slides, you have seen that one of the discretionary powers of governor is what? He can recommend dissolution of assembly only if the ministers have lost the confidence. But that should not be based on his subjective assessment. Like, it should not be based on his own understanding, but it should be based on the majority testing on the floor of the house. That was made clear in SR Bommai versus Union of India case. So these are the important Supreme Court judgments which you can quote in your mains answer relating to answers involving governor or federalism or central and state relations. Now, from time to time, there have been various commissions established to see how the administrative or how the Indian polity is working, and they have given the recommendation. So these are some important committee recommendations which you can use in your mains answer, and these have also been directly asked in prelims examination. So it is important to know certain important recommendations of this commission regarding the office of governor. So first and foremost, there is Sarkaria Commission. So we have seen that governor's appointment is under the hands of president, and there are no qualifications mentioned apart from that he should be a citizen of India and 35 years of age. So there are high chances that central government may appoint politically motivated person to the office of governor, and this may cause a friction between the federalism, between the cooperation between central and state government. So the Sarkaria Commission recommended that with regards to governor appointment, the respective state CM should be consulted, and eminent persons from outside the state should be appointed, so they are not involved politically in that state, and they should avoid intense political links. Now, this is to ensure the sanctity of governor's office is maintained and he is free from any political intervention. Similarly, the Sarkaria Commission also recommended that governor can only be removed on grounds of morality, dignity, and constitutional propriety. That is, currently there is a doctrine of pleasure which is applicable, which means that president can remove the governor. They have no grounds mentioned. Now, what happens is this causes a reduced independence in the governor's office, and it also causes a lot of political intervention. Now, to reduce that political intervention, Sarkaria Commission recommended that governor should be only removed on certain grounds, and those grounds should be mentioned clearly in the constitution. Similarly, Second Administrative Reforms Commission has said that interstate council should provide guidelines for governor's discretionary powers. Now, you have seen that governor has certain discretionary powers. For example, governor can reserve any bill of the state for consent of president. That is his discretionary power. And there are no guidelines or there are no codified procedure in what cases the governor can reserve the bill. Now, this causes a lot of friction between functioning of governors, which we have seen in recent news in case of Tamil Nadu or Telangana. So what second ARC recommended is, and who should be do it? Interstate council. So interstate council has participants from all the state governments in center, and they can form certain guidelines which can control the governor's discretionary powers. Similarly, Punchi Commission also recommended certain points for office of governor. First is the term should be fixed for 5 years, and there should be an impeachment process for removal. So this will ensure that the governor's office is not dependent on doctrine of pleasure, and like president at center has impeachment process for removal, so governor can have a similar kind of impeachment process. This will give a lot of independence to the governor's office. Again, Punchi Commission also recommended that non-political individuals should be appointed, and it should eliminate the convention of governors as university chancellors. Now, we have seen in a lot of states the issue of governor's role as university chancellor has been appointed. That is a causing a friction between the working of state government and governor. So, Punchi Commission recommended that governor should not be involved in any case which jeopardizes its independence or which makes him involved politically. So one of the such role is role of university chancellor. So Punchi Commission recommended that eliminate the convention of governor as university chancellors. So these are the important recommendations which you can quote in your mains answer, which are also been asked directly in prelims. So they are important to note it down. Okay, so now we have discussed around all the topics around governor. Now this is an ongoing topic. As you have seen that the Tamil Nadu case is still ongoing, and we may see Supreme Court's interpretation on Article 200. So there may be certain new interpretations or new issues around governor, which we can discuss later. But as of now, whatever topics were in news and its static part have been covered in this presentation. So based on this, let's see some previous year PYQs which have been asked by UPSC regarding the topic of governor. So the first question is, which of the following are discretionary powers given to governor of state? First is sending a report to president for imposing the president's rule. Second is appointment of ministers, reserving certain bills passed by state legislature for consideration of president of India, and making the rules to conduct the business of state government. Now, we have seen in discretionary powers of governor, these are the constitutional discretionary powers of governor: reserving the bill, recommending report for recommending president's rule, and etc. etc. So we from that source we can answer this question. So this is the discretionary power of governor. Appointment of ministers is always done on the advice of chief minister. So this is not a discretionary power. Reserving bill is a discretionary power. So the answer will be 1 and 3. Now, other question, this was asked in UPSC 2019. Which of the following suggested that governor should be eminent person from outside the state and should be detached figure without intense political links? So this we have seen, Sarkaria Commission at first recommended that the governor should not have any political links, it should be an outside person. So the answer for this will be Sarkaria Commission. And there was one more question regarding the governor's office, which was asked in 2018. This is regarding the immunities provided to the governor's office. So first is, no criminal proceeding shall be instituted against the governor of state in any court during his term of office. The emoluments and allowances of the governor of a state shall not be diminished during his term of office. Which of the statements above are correct? So I have seen both of this in the constitutional provisions, both are correct. So answer will be C, both 1 and 2. So that's all regarding the governor's office. Yeah, thank you.